Think about the CASS source book, then it does cover a number of different areas, and not all of them apply to every firm, of course. But where we started out was in allowing the firms to prove that they complied with CASS 7, the client money rules. And then quite quickly after that, we talked to the firms about how they could use the software to prove that they complied with the CASS 6 custody rules, and then keeping track of mandates under CASS 8, and then some insurance firms were interested in how they could prove their compliance under CASS 5. But does it just vary firm to firm about how challenging those different areas are? Or would you say that a particular area of the CASS regime has remained quite difficult for firms to comply with? Is client money a harder area to prove compliance with than custody? If I think about some of the big banks we would speak to who were involved in custody, they would have a large network of sub-custodians, and many of those would be overseas. So keeping track of that oversight and doing the due diligence was quite a big problem. But there are obviously challenges in client money and trust letters and prudent segregation as well. So no area is free from challenge. But how would you compare the different areas?
I think it really does depend on the type of firm, the type of activity they're doing, and how big a CAS firm they are. If you can imagine that you've got a fund manager, for example, who's got multiple custodians on different funds, and they may be located in different countries as well. You're not just looking at what the CAS requirements are in the UK, you've got to look at those requirements in those different countries and make sure you're complying with those in those specific countries as well. So regardless of what you as a group entity, for example, might see as your CAS risk overall, you've got to make sure that you've got an eye on the ball in each of those different jurisdictions. And that, for me, would be a headache.
Yeah, yeah. It makes a lot of sense. Maybe one last thing is we found that the appetite for using technology was much more prevalent in wealth managers, asset managers, and custody firms. That was where our initial client base emerged from. And obviously the banks were under slightly sort of a lesser regime because they could use the banking exemption to sort of, carve out some area of the rules that they didn't need to apply to. Would you say that banks actually have it easier when it comes to looking after client money in that respect because of the banking exemption? Or do you think that they've actually got other challenges under the regime which are just as difficult for them to comply with overall?
Yeah, I think that comes back to the fact that it's a different type of regulated entity. So a bank won't just have to comply with the conduct rules or the FCA requirements. They come under the jurisdiction of the FCA and the PRA. So they've got extra stuff they need to deal with. It's everything around deposit taking, safeguarding those assets, the client money. But they've also got to track it as well. They've got to also make sure that they know where those monies are held. They've got to make sure those are segregated as well. They can't mix that with their own funds. So the segregation is important. On top of that, you've got the stress testing, you've got the resilience and resolution requirements for banks as well. So it might sound as if they don't need to comply with CAS, but actually they've got a whole load of requirements that they need to comply with as well.
Yeah, yeah, makes perfect sense.